Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we continue our video series designed to educate and inform the public, so please subscribe to our channel. You know, when we talk about provisions in the judgment of divorce, a lot of times people will ask us, well, what provisions can we put in to address eventualities that will occur in the child's life later on down the road? And the answer is, you really can't. I mean, you can put standard provisions in that have to do with certain changes in circumstances, but even if you don't put them in, the court can always revisit custody if there's a significant change in circumstances that supports the court doing so. But I think a lot of people make the mistake of believing that the judgment of divorce can be drafted in such a way to cover every eventuality of a child's development. And really, it can't. I'll have people who will come to me and say something like, well, when the child was 11, mom was the custodial parent, but now that the child's 14, it'd be better if the child was with the dad. The child needs the dad's guidance in his teen years. Well, guess what? When the court gives a custody order, it contemplates that your child is going to live through teenage years. Sometimes you wonder how, but it's contemplated that there will be teenage years. It's contemplated that the child will go through different stages of development, and that itself is not going to be enough to change custody. So don't go into it thinking, well, once the child, hits a certain age level, custody will change. Or surely the court will see that the boy needs his dad now more than ever. It doesn't work that way. When the court makes a ruling about custody, it well understands that there will be a development in the child. It well understands that there will be a sweet 16, that the child is going to get a driver's license, that the child's going to care more about hanging out with his buddies than he will with his parents. It's just the way it goes. The court contemplates this. So therefore, when we talk about changes in circumstance that supports the court revisiting and maybe even changing custody, the eventual passing of time is not one of those circumstances. So when we talk about the needs of the child changing, if in fact medical needs change, you can bring that motion. You can say, you know what, mom is better at it because the child now has these needs that mom knows how to handle better than dad. You can bring that to the court's attention without putting a provision in the judgment of divorce. You don't need to preserve that right to bring it before the court. However, unless it's something that couldn't possibly be contemplated by the judge at the time that he or she awarded custody, expect that the court will say, well, what's the big deal about that? We know the child's going to get taller. We know the child's going to get older. We know that the child's going to get a girlfriend or a boyfriend. We know that these things are going to happen. It's like the kids develop and parents have trouble with it. And they think that the changing of the child, the growth of the child into a young adult is a reason to change custody. It's the old story where a 16-year-old girl comes down the stairs as she's getting ready for a date. And the father says to the mother, "Are you aware that she's wearing makeup? I don't approve of that." And the mother says, "Excuse me, but you got to realize she's 16 years old." And the dad goes, "Well, you know what? I don't approve of that either." So it's like there are changes that come up. These are known contemplated changes. And amongst them is that your children are going to grow. So it's not going to be enough for that. So when we talk about the changing of needs to justify the changing of custody, we're talking about things that could have been contemplated. And can the judgment be in advance written so that those needs are contemplated? Really hard to do so without a crystal ball. But rest assured, even if it's not in the judgment, you can file a post-judgment motion to modify the custody based on the significant change in circumstances. If you have any questions about that, reach out, and we'll be glad to help you out.